Assalamualaikum and a very good evening. My name is Muhammad Nur Hafiz bin Muzham, and today I will be presenting about discharge of contract by performance and agreement. So here we go. So basically, discharge of a contract associated to the circumstances in which the deal was being terminated to an end. Where a contract is being ended, each party will dismiss from their continuing obligation under the contract. Discharge by performance would be when both parties end obligation from the contractual obligation. If one of the party does not fully perform the contract, this will amount to a breach of contract, and both the other party may have a claim for damage, unless the deal has been infuriated. The crudity of this rule relating to discharge through performance has been mitigated by the creation of various exceptions. There are 5 of them: severe over contract, substantial non-performance, acceptance of partial performance, performance prevented by the promise, and also tender of performance. Next will be discharge by agreement. Discharge by the agreement will done when both parties agree to bring the contract to an end. By ending their contract, it means that they release mutual from their contractual obligation. The discharge agreement should be accord and satisfaction. Both of these terms should remain applied to ensure the discharge are being sincere. That's all from me. Thank you.
Hello there. My name is Muhammad Shahrul Akmal bin Muhammad Samad. I will explain about discharge by breach of contract. In short, discharge by breach of contract. When a party fails to perform their obligation as agreed, they are in breach of contract. Breach occurs when a party to a contract fails to fulfill its obligation, whether partially or wholly, as described in the contract or communicate as intended to fulfill the obligation. There are 3 ways of breaching contract. First, fail to perform their obligation. Second, behave in a manner which show an intention. Lastly, the contract becomes impossible to perform as a result. Next, type of breach. First, material breach. Second, minor breach. Third, anticipatory breach. And lastly, actual breach. First, material breach. Generally, a material breach of contract involves one of the key elements of the contract not being provided or undertaken as agreed. Second, minor breach. It is important to be clear that not all breaches of contract will be material and hence immediately end the wrong party obligation. Third, anticipatory breach. An anticipatory breach occurs when a party demonstrates his intention to breach of contract. Lastly, actual breach. This is of course the most common way that a party will breach a contract. It occurs when the time arrives for a party to perform their side and agreement and they don't perform. Last part, effect of breach. If one party fails to perform their obligation under the contract or breaches a condition, the innocent party is entitled to treat the contract as ended from the time of the terminating event. The party in default cannot terminate the contract which he himself had broken. Thank you.
Hello, my name is Zainal Harid. So today I will present to you topic discharge by frustration. What is discharge by frustration? A contract may be frustrated where there exists after the contract was made, which is not the fault of either of the parties, which render of the contract either impossible to perform. Okay, for the example of frustrating event, back in 1975, Qatar Power as a Qatar had promised to serve as a schematic for the whole of the voyage but had not done so. The contract was not feasible as the payment was supposed to be full payment. Since the Qatar did not perform his promise, there was no right for the window on any part. The contract will not be frustrated where it's more difficult to perform, the possibility the fault of either of party, where is the force major clause. Effect of frustration. The effect of frustrating event is not discharge of the contract immediately, but only as to the future. The contract is not void. Okay, that's all from me. Thank you very much.
Hi, Hello, my name is Amir Zainal. I will introduce about rescission part and a restitution part. Let's go. Rescission part. In simple terms, rescission involves cancelling a contract as long as it was never executed. Rescission is frequently used in the insurance industry. Life, health and property casualty, insurers have the right of rescission for insurance policies. For the example, in California, the law allows the right of rescission for over 30 different types of consumer contracts, including funeral service contracts, automobile purchase contracts, and door-to-door sales contracts. The second one is, the most common example of rescission is the 3-day right of rescission, in which a borrower refinancing a loan has extra time to reconsider the rescission. The clock on the rescission process begins ticking the moment the contract is signed by the borrower. The borrower must affirm the decision to exercise the right of rescission by midnight of the 3rd day after signing the contract. Okay, let's go for the next part. Restitution part. Restitution applies to the measure of the damage required to restore the plaintiff to the position he or she held prior to the commission of the tort. Basic purpose of restitution is to achieve fairness and prevent the unjust enrichment of a party. Restitution is used in a contractual situation where one party has conferred a benefit on another party but cannot collect payment because the contract is defective or no contract exists. For the example, if a person is injured by another person, the injured party may collect medical expenses and lost wages as restitutionary damages. The second one is, when the shoplifter has to give back or pay for the item he stole, by making good for loss, damages, or injury by the identifying the damaged party, return or restoring something to its lawful owner. Okay, that's all from me. Thank you. Bye bye.
Hi, my name is Ahmad Rafai bin Khairi, and I will explain the Remedies Chapter 2. There are many types of remedies. One of each is damages. Okay, this is the meaning of damages. Damages in contract law are a legal remedy available for breach of contract. Damages are an award of money to compensate the innocent party. For the purpose of damage in contract law is to place the injured party in the position they would have been in had the contract been performed. For your information, this is an example of the section 74 for the damages remedies. Okay, next, I will explain about the contract of remedies, about the specific performance. This is the meaning of the specific performance. Specific performance is a discretionary remedy granted by the court, and it is under the Specific Relief Act 1950. It's often ordered in relation to the building contracts because the contract deals with the result or the carrying on of an activity over a period of time. This is the example for the section 20 in the specific performance. Furthermore, on the topic of remedies, we have injunction. Injunction is classified under Part 3 of the Specific Relief in 1950. Injunction will not be granted if its effect will be to compel a party to do something which could not have been ordered to do by a specific performance. This is an example of cases in the section of 43, the Henry Ford Properties Ltd vs. Cheshire Country Council.
Hi, my name is Muhammad Shahid Sinwan. In this section, I will be explaining about the remedies of Anton Pillar Order and Quantum Merit. Let's start! Anton Pillar Order. It is a court order that provides the right to search premises and seize evidence without prior warning. If the defendant has the incriminating evidence in his possession, he might destroy it before a discovery order can be issued by the court. The evidence might be important for the plaintiff's case. Let's move on to the next remedy. Let's go! Quantum merit. It is a Latin phrase that means one has earned. In the context of contract law, it means reasonable value of service. Quantum merit can arise when a defendant has prevented a plaintiff from carrying out the remainder of the contractual duties, the parties cannot agree on payment, or the parties agrees on payment for the part performance but not the actual amount. The end. Thank you for tuning in.